Contractual issues. Work agreements are legal documents also, and contractually specify the ownership terms of work created. This comes into play when you're doing spec work, pro bono work, and work for hire. Spec work. So spec work is when payment for design services are paid at a later date because of some external occurrence. Be really cautious of spec work because it happens when somebody wants something from you, and as a designer, you want that experience, so you go ahead and you do it, but then you don't get paid. So it requires that you as the designer present ideas without payment. So the work is really deemed speculative. Now, design competitions sort of fall into this spec work because only the selected design receives payment or other enticements to create design products for commercial use without being paid before. Overall, spec work is really frowned upon throughout the creative industry, the creative services industry. It really is unethical to ask someone who has a limited number of hours to earn a living to risk that limited resource without compensation. Spec work does not allow a designer to appropriately budget time and expenses to solve whatever issue or whatever problem has been brought to them. So it's more of an exercise in using design software quickly. So it's a personal choice whether to do spec work or not. As a beginning early on designer, spec work really is a good way to get some experience, but know that you probably are not going to be compensated for that time. Many cases, though, the compensation comes from building your resume and building your portfolio. Pro bono work. So pro bono is a Latin phrase meaning for the public good. Pro bono work is meant for nonprofits, a nonprofit organization that you personally feel strongly about it. You feel that they are worthy of receiving some free work to help their cause. So it's really valuable to build community contacts, and again, it adds work to your portfolio. So pro bono work, though, needs to remain a standard contractually agreed project. Everything you would do in a paid design engagement should be spelled out in writing with a pro bono client. So you're going to go through the scope, the deliverables, the schedule, the assumptions, and the use of work. Make sure with the pro bono work that you also, in your contract, list that you will have the right to put this piece or the pieces in your portfolio. Work for hire. Work for hire means that a design was created in the course of employment. If this is the case, the copyright then belongs to the company, not the individual designer. So the contract will state if and how the designer may show the work or take credit for its creation. Works made for hire or work for hire, typically what we see here. So remember, in the work for hire, the employer, whoever the other compensating party is deemed to have created the artwork for the purpose of copyright law, leaving the artist with no right whatsoever. So an artist acts as an independent contractor. The artist has no access like a traditional employee would to benefits for compensation for the loss of those copyrights. The last one we're going to talk about is assignments. If work for hire agreement is not in place before the work begins and the designer is not an employee, then the intellectual property rights stay with the author of the work, who is the designer. So without an agreement executed in advance of the work with the term work for hire spelled out, then the authorship is not transferred, and instead some limited use of the work is what actually is being purchased. So assignment of rights. If the client wants to retain all the rights of the work, the closest thing to work for hire they can negotiate after the work begins on an assignment is the assignment of rights. This lasts for 35 years. So unlike a work for hire, in which the authorship rights are permanently transferred, an assignment only lasts for 35 years. So after the 35 years, then the designer regains full rights to that piece. So an assignment signed out today could mean owning at least a partial licensing right to valuable work in the future, 35 years down the road. So the rights do revert back to the creator of the work, even if the contract expressly states otherwise.